Welcome, everybody. Welcome to today's episode of the Law of Self-Defense Show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you. Can't believe that comes over the internet like that. That's amazing. Make yourselves comfortable, folks. Today we are going to talk about of others, defense of others. Let me make sure everything is working as it should, except of course, my own website is making me log in. That's a good thing. Let's see. And the password is not password, folks. There we go. Make sure Rumble is working. And make sure Twitter is working. Let's see. Let's fix this, fix that. I don't know if it is working. Come on, Elon. There we go. All right. Whoops. Almost deleted my own show. That would have been awkward. And finally, last but certainly not least, our Law of Self-Defense members, and it's streaming as well. All right, everybody is here. Grab a seat. As always, we only take questions and comments from Law of Self-Defense members in the Law of Self-Defense member chat. And today, I had promised today was going to be a members-only show, but the Daniel Penny case in particular is of sufficient public interest that I thought I'd make a portion of the show open access. So here's what we're going to do, folks. We're going to make it a split show. The first 30 minutes of the show is going to be open access. And at the 30-minute mark, YouTube, Rumble, and Twitter stream ends. When that happens, if you're a Law of Self-Defense member, don't go anywhere. If you're on the member dashboard, just stay right there. We'll continue the show with the Law of Self-Defense members. Everybody else, if you're not a Law of Self-Defense member, the show ends at the 30-minute mark. The good news, of course, is that it's very easy and cheap to be a Law of Self-Defense member. You can sign up right now for just 99 cents, folks, for 2 weeks of unlimited access to all our members-only content. That's thousands of videos, podcasts, blog posts, plus, of course, the second half of today's show. You can sign up right now, lawofselfdefense.com/trial. And if you stay a member after the 2 weeks, it's still dirt cheap. It's only about 30 cents a day, folks, less than $10 a month to be a Law of Self-Defense member, get unlimited access to all our members-only content. And if you find that you like that deal, you might want to take advantage of this one. That's becoming not just a standard Law of Self-Defense member, but a platinum member. We have an offer right now, 5 years of my platinum protection coverage that guarantees you my legal services as a legal consultant if you're involved in a use of force event. Got another murder acquittal just last week, folks. It matters. And as a platinum member, you get that legal consult for free. We don't take outside consults anymore, so the only people who can qualify for a consult from me are our platinum members. When we did take outside consults, they were a minimum of $10,000. But as a platinum member, you get that consult for free for being a platinum member. Get 5 years of that coverage. Also get $3,000 worth of our Law of Self-Defense educational content. All of that for 82 cents a day, folks. 82 cents. I don't know how you can beat that offer. You might want to take a look at that. lawofselfdefense.com/82 cents. But at the very least, I would encourage you to become at least a trial member of Law of Self-Defense at lawofselfdefense.com/trial so you can enjoy the second half of today's show. All right, with that out of the way, let's jump into the start of the substance of today's show, talking about defense of others, illustrating those concepts with Daniel Penny, the New York City subway chokehold defendant, and a new gentleman, Jordan Williams, who also killed someone on a New York City subway, this time using a knife, purportedly in defense of his girlfriend. So let's launch. Here we go. All right, so we're here to talk about defense of others. It's a more subtle topic than most people might imagine, and we're going to help provide kind of a framework for thinking about the various forms of defense of others, the different risks that different forms of defense of others take. And so to help all of you make an informed decision. I don't tell people what to do, so I don't tell people to come to the defense of others or don't come to the defense of others. That's your decision to make. But I do want to help you try to make an informed decision so you understand the risks you're incurring, why those risks exist, and how to mitigate those risks in coming to the defense of others. And we can illustrate this with some breaking news involving two defense of others situations, both happening in the New York City subway system, which, if you've ever lived in New York City and used the subways, is not as surprising as you might think if you've not had that experience. As a former New York City resident myself, having spent my share of hours in the subway system in the pre-Giuliani days, which is increasingly parallel to the days we're seeing in New York today, unfortunately, I've had my share of experiences with interesting people on that subway system, including threats and acts of violence. But 2 days ago, Daniel Penny, of course, is the former Marine who was on a New York City subway car when Jordan Neely, a man with a long history of making threats of violence on New York City subway cars, came onto the same subway car, started making threats to the passengers on the car. Daniel Penny put Neely in a chokehold position to secure him, restrain him until police who had been called could get to the scene. It took the police 10 or 15 minutes to get there, unfortunately. And in the course of being held in the chokehold, Jordan Neely died. Now, does that mean he died from the chokehold? I would suggest not. In fact, I just consulted on a case, provided expert testimony on a case here in Colorado just last week. A week ago today, I was providing expert testimony in a chokehold death case in Colorado, where one man was incontrovertibly, uncontested by the prosecution. The defendant was the victim in the initial act of aggression. He was attacked by someone much larger than him, 5 inches taller, 50 pounds heavier. The defendant was attacked by this gentleman, and the attacker was outrageously intoxicated. 0.43 blood alcohol level. 0.43. That's not a typo, folks. 0.08 is drunk driving, so more than 5 times the drunk driving limit. And the defendant put this dude in a chokehold, and the dude died. And the defendant was charged with murder, reckless manslaughter, and criminally negligent homicide. So he was looking at spending the rest of his life in prison as of last Friday. When I provided my expert witness testimony, I was the last witness the jury heard before they went into deliberations. They only had about an hour to deliberate Friday afternoon, but they came back Monday morning and they acquitted that defendant of all charges. And I'd like to think, and in fact, his defense counsel tells me that they spoke with the jury afterwards, that my testimony was pivotal in securing that acquittal on all those charges for that defendant. And one of the arguments the jury was asked to consider was, in fact, that the chokehold did not kill the victim. That what killed the victim was the victim's severely impaired physiology. Because this victim, in the case I testified in Colorado, the person was alive with a 0.43 blood alcohol level because they were a chronic lifelong alcoholic. They had relatively severe heart disease. They had really severe liver disease. This was a person who was far from healthy. And most of what we're taught about how chokeholds work, I'm a student of jiu-jitsu. Chokeholds are a normal part of jiu-jitsu. We're told things like 6 seconds to unconsciousness, 1 minute is a risk of brain damage, 3 minutes is a risk of death. But all those metrics are developed in the context of healthy people, right? People who go to jiu-jitsu studios to practice. They're not ill. They're not sick. Or they're developed in the context of world-class athletes, MMA fighters, for example. They're not developed in the context of lifelong alcoholics with heart and liver disease. So one of the things the jury in the Colorado case, in which I testified, was asked to consider, that it wasn't actually the chokehold that killed the victim. It was his own physiology that killed the victim, that there was no way for the defendant to know that what he was doing, what he was trained to do in this circumstance, could result in death or serious physical injury to the defendant. And by the verdict, we can infer that the jury thought that a compelling argument, found that defendant guilty of all charges. And frankly, that's the argument Daniel Penny's attorneys will likely be making as well. That what killed Jordan Neely was not the chokehold, but what killed Jordan Neely, also a homeless drug addict, was his impaired physiology, and that it was entirely unforeseeable by Daniel Penny that the chokehold position he put Neely in would result in his death. I expect that's the legal argument we'll see in that case. So let's take a look. Nevertheless, despite all that, of course, Daniel Penny was just indicted by a New York grand jury, not on a charge of murder, like my Colorado client was indicted. My Colorado client was indicted on murder, reckless manslaughter, and criminally negligent homicide. Daniel Penny's been indicted not on murder, but for reckless manslaughter and criminally negligent homicide. And I'll talk about the distinction between those two crimes in a moment, because they do involve different states of mind. And importantly, the defense of self-defense works differently in the context of murder and in the context of reckless manslaughter and criminally negligent homicide. In the context of murder, self-defense, raised as a legal defense, is an affirmative defense that the state has to disprove self-defense beyond any reasonable doubt. But when the criminal charges are reckless manslaughter and criminally negligent homicide, self-defense is not an affirmative defense, and the state does not have to disprove self-defense beyond a reasonable doubt. Didn't know that, right? We're going to cover that in more detail in just a bit. All right, so let's take a look at a news story we have here about the indictment. This is out of the New York Daily News. Here we go. Let's see. We don't need this. And I'll zoom that in a bit so it's easier for all of us to read. A Manhattan grand jury has voted to indict Daniel Penny for the chokehold killing of Jordan Neely aboard an F train, law enforcement sources told the Daily News on Wednesday. The former Marine was indicted on one count of second-degree manslaughter, that's reckless manslaughter under New York law, and one count of criminally negligent homicide for Neely's May 1st killing, a law enforcement source told the news. The grand jury began hearing the case 2 weeks ago. 2 weeks? 2 weeks of testimony to the grand jury on this case? Or they were given 2 weeks to think about it, maybe 1 day of presentation of evidence by the prosecution. The Manhattan District Attorney's Office declined to comment. The charges will remain under seal until Penny appears in court to enter his plea. Well, I guess they're not under seal anymore, are they? Thanks to a law enforcement source. Penny's lawyers indicated they would fight to prove his innocence. Interestingly, normally in a self-defense case, a defense of others case, if someone's charged, again, with an intentional killing, a murder, and they raise the legal defense of self-defense, the defense doesn't have to prove anything. The state has to disprove self-defense beyond a reasonable doubt. But so this sentence would make no sense. The lawyers indicated they would fight to prove Penny's innocence. If this were a normal self-defense case, an affirmative defense self-defense case against the charge of an intentional killing, they don't have to prove anything. They certainly don't have to prove their client's innocence. The state has to prove the defendant guilty of the crime, which isn't hard in a typical self-defense case, because the legal defense of self-defense is a legal defense of confession and avoidance. So you're confessing to the underlying conduct. You're not saying it wasn't me, I didn't shoot that guy. You're saying it was me, I shot him, but I did it in self-defense. You confess to the underlying conduct, you seek to avoid legal liability based on the justification of self-defense, confession and avoidance. That's to an intentional killing charge, like murder. And when you do that, the state has to disprove self-defense beyond a reasonable doubt. But Penny here is not charged with murder. So self-defense won't be raised as an affirmative defense that the state has to disprove. Instead, Penny's been charged with unintentional killing, reckless manslaughter, and negligent killing, criminally negligent homicide. Those are not intentional killings. And so if you're not doing the confession and you're not confessing, I killed him on purpose, but I should avoid liability. You're saying, I never intended that guy to die. And the state's saying, well, you should have known he was going to die because your conduct was reckless or your conduct was criminally negligent. And when that's the criminal charge, an unintentional killing, the legal defense of self-defense is not an affirmative defense that the state has to disprove beyond a reasonable doubt. The way it works instead is, of course, in reckless manslaughter, one of the elements of reckless manslaughter, one of the elements of the crime is recklessness. What is recklessness? Recklessness is when you know you're creating an unjustified risk of death to a person and you intentionally ignore that risk and death results. So a classic example would be drunk driving. You get drunk at a bar, you get behind the wheel of your car, you're driving home drunk. You're not trying to run anybody over, quite the opposite. You're just trying to get home. But you know that drunk driving creates an unjustified risk of death to other people. And then you unintentionally run someone over and kill them. So you knew you were creating an unjustified risk of death to others. You deliberately ignored that risk, and a death resulted. That would be a reckless manslaughter. So one of the elements of the crime, reckless manslaughter, is, of course, that reckless conduct. The way self-defense as a legal defense works in that context is not as an affirmative defense the state has to disprove beyond a reasonable doubt. Instead, what you're essentially arguing is that, well, the state claims my conduct was reckless, but I claim my conduct was self-defense. And if my conduct qualifies as self-defense, it cannot have been reckless because one of the required elements to qualify as self-defense is reasonableness. That my use of defensive force was reasonable under the circumstances. And so if you believe it was self-defense, if you believe I've met the conditions for self-defense, then you're also believing my conduct was reasonable, and reasonable conduct cannot be reckless. Recklessness requires that the conduct was unreasonable, an unjustified risk of causing death to another person. So you're not raising an affirmative defense the state has to disprove. You're negating one of the elements of the criminal charge. Now, remember, for an intentional killing, you're conceding to the elements of the criminal charge. You're saying, yes, I did all that. I shot that person. So you're not denying the elements of the criminal charge. But you're saying, despite all the elements being proven beyond a reasonable doubt, I still should not be held guilty because I did it in justified self-defense. I have the escape hatch of legal justification. In the context of reckless manslaughter, that's not what's happening. What's happening is the defense is saying, the state has failed to prove one of the elements of the criminal charge. They failed to prove recklessness because my conduct fits the definition of self-defense, and self-defense is inherently not reckless conduct. And then the jury has to decide whether or not the state failed to prove that element of reckless beyond a reasonable doubt. And the same framework works in the context of criminally negligent homicide. Now, criminally negligent homicide is different than a reckless killing. A reckless killing is when you knowingly create an unjustified risk of death and you deliberately ignore that risk and death results. Negligence is different. Negligence is when you didn't know. You actually were not thinking about the risk you were creating, but you should have known you were creating a risk. A reasonable person would have known you were creating the risk, and then the harm results. Now, negligence is normally a civil liability concept. It's not enough to rise to criminal liability. Normally, negligence, you just get sued in civil court. Maybe there's a monetary judgment, but you're not going to jail. Criminal negligence is when an act of negligence occurs in the context of conduct that's inherently dangerous. So this could be in the handling of a gun or explosives or dangerous chemicals, where you might not have known you were creating a risk, but a reasonable person knows that guns, explosives, chemicals are dangerous things, and a reasonable person would have known they were creating the risk. That escalates because of the inherent dangerous nature of the conduct, escalates what would have been just civil negligence to criminal negligence and creates criminal liability. So here, what the state is arguing on the facts of the Daniel Penny case, when they argue reckless manslaughter, they're arguing Daniel Penny knew when he put Jordan Neely into the chokehold, he knew he was creating an unjustified risk of Neely's death. He ignored that risk. He did it anyway. He didn't intend to kill Neely, but he knew he was creating that unjustified risk of death. He ignored the risk. death resulted, reckless manslaughter. And with respect to criminally negligent homicide, the state is arguing that when Daniel Penny put Jordan Neely in that chokehold, maybe he didn't actually know he was creating an unjustified risk of death, but a reasonable person should have known. And putting someone in a chokehold is inherently dangerous activity. That escalates the conduct to criminal negligence. Death resulted, criminal negligent homicide. And the defense response to both those charges will be, well, it can have been reckless if it was lawful self-defense, because self-defense is inherently reasonable, not reckless. And it can have been criminally negligent or even negligent if it was unlawful self-defense, because self-defense is inherently reasonable, not negligent, much less criminally negligent. So those are the legal arguments around the criminal charges here. And the different way that the self-defense argument works with respect to unintentional killings as opposed to murder in intentional killing. For those interested in the legalese, we refer to raising self-defense to an intentional killing as an affirmative defense that the state has to disprove beyond a reasonable doubt. When we're talking about an unintentional killing like reckless manslaughter, criminally negligent homicide, and we raise the legal defense of self-defense, it's no longer an affirmative defense. We don't call it that. We call it something else. We call it a traverse defense that neutralizes an element of the underlying criminal charge. Traverse, Traverse for the law nerds out there. You don't see that a lot in the legal literature. It doesn't come up a lot. If you Google it, you may have trouble finding information on it, but that's how it works. Let's see. One of Penny's attorneys, continuing now with the news story, we're confident that when a trial jury is tasked with weighing the evidence, they will find Daniel Penny's actions on that train were fully justified, attorney Stephen Razor said in a statement. Well, this raises an interesting point too. He says, when a trial jury is tasked with weighing the evidence, meaning weighing the evidence in favor of guilt and the evidence in favor of not guilt. At trial, the trial jury hears both sides of the story. It's an adversarial process. The state presents its case in chief, and then the state rests, and the defense gets to present its case in chief, call its witnesses, present its evidence. And then, of course, at closing, the state makes its argument, presents its narrative for guilt based on the evidence and testimony presented in the trial, and the defense, in closing, presents their argument, their narrative for not guilt based on the evidence and testimony presented in trial. And then the jury has to decide. But the jury hears both sides. The trial jury hears both sides of the argument. The grand jury, folks, does not. The grand jury hears only one side of the argument, the prosecution side of the argument. And if you've ever only heard one side of an argument, you know it sounds compelling until you hear the other side. So effectively, grand juries are rubber stamps for the prosecutor. The grand jury's outcome, an indictment or no true bill, no indictment, is the result of what the prosecutor engineers into the grand jury, what the prosecutor wants. If the prosecutor wants an indictment, he tells the grand jury a story consistent with an indictment, and they give him an indictment. If a prosecutor does not necessarily want an indictment, but maybe he's just going through the grand jury process for purposes of political cover, he may, at his discretion, share with the grand jury evidence both favoring guilt and favoring not guilt. But when he's doing that, it's because he's giving the grand jury, deliberately giving the grand jury an opportunity to return a no true bill, to decide not to indict. That doesn't happen often, but it happens sometimes. It happened in the Michael Brown shooting, for example. That's why that officer who shot and killed Michael Brown was not indicted by the grand jury, because the grand jury heard both sides. And if you heard both sides of that narrative, you couldn't possibly return an indictment, and they didn't. Here, the fact that the grand jury returned an indictment, all that means is the grand jury, as always, is a mirror of the prosecution. The prosecution wanted an indictment, told the grand jury a story consistent with an indictment, and the grand jury returned an indictment. The indictment is inevitable if that's what the prosecutor wants. All right, continuing now with the news story. Reverend Al Sharpton, who previously called for Penny to be charged, welcomed the development. Well, of course, Al Sharpton's a racial arsonist. He makes money off of racial division and hate and turmoil. So, of course, he's happy that this becomes as aggravated a narrative as possible in the racial context. Al Sharpton being quoted now, "This was a clear-cut case of vigilantism that has no place in our society," he said in a statement. "It appears Mr. Penny's media tour these last few weeks was ineffective." Well, I guess Al's suggesting that the release of a Penny interview was ineffective in keeping the grand jury from returning an indictment. The grand jury didn't see that interview, or if they did, they were told to ignore it. So, of course, it wasn't going to influence the grand jury. Mayor Adams, who has refrained from directly condemning Penny's actions, said he had faith in the legal process and appreciated DA Alvin Bragg's investigation. Addressing subway crime has been a top priority for Adams. This is an interesting case because 5 years ago, I would have expected Major Adams to come out fully on board the racial arsonist bandwagon. Daniel Penny's a racist murderer, must be held accountable. Why do these white people keep doing bad things to black people? But he's not doing that. He's not doing that. And I have to believe he's not doing it because crime on the subway has become so bad that the political dynamics of just blanket favoring Jordan Neely over Daniel Penny would be politically perilous for the mayor. That's how bad things have gotten. Quoting the mayor now, quote, "Like I said, when the DA first brought charges, I have the utmost faith in the judicial process. And now that the grand jury has indicted Daniel Penny, a trial and justice can move forward," the mayor said in a meaningless statement. Bystander video showed Penny, 24, holding the 30-year-old Neely in a minutes-long chokehold until he stopped moving. The Manhattan DA brought manslaughter charges on May 11th, and Penny was released on $100,000 bail. Neely grew up in Manhattan and was known to many New Yorkers as a passionate Michael Jackson tribute artist. How many New Yorkers? As a percentage of the 15 million people that live in the greater metro area. Oh, he battled severe mental illness and homelessness, according to relatives and friends. And he had a long history, recorded history with New York PD law enforcement of engaging in this kind of violent conduct on subway cars. That's not in the article. I'm just sharing that with you. Penny, an architecture student who was unemployed and looking for work at the time of the incident, has contended he acted to protect himself and other passengers from an erratic Neely. Well, I don't think he put Neely in a chokehold just because he was erratic. If Neely was having convulsions, he wouldn't have put him in a chokehold. I expect Penny would say he put Neely in a chokehold because Neely was acting dangerous. Messages were left with a representative for Neely's relatives. In a pre-taped video released by Penny's legal team earlier this week, the East Village man said his actions were driven by courage. Quote, "I acted in a way that would protect the other passengers, protect myself, and protect Mr. Neely," Penny said in the video posted on the Law and Crime Network YouTube channel. I believe I covered that interview in a Law Self-Defense content last week, for those of you interested in looking back. Quote, "I didn't want to be put in that situation, but I couldn't just sit still and let him carry out these threats." Close quote. What happened before the chokehold will be a crucial focus if Penny pleads not guilty at his Manhattan Supreme Court arraignment and the case reaches trial. A trial would take place unless prosecutors and Penny make a plea deal, which would require him to admit wrongdoing. There won't be any plea deal here. And of course, he's going to plead not guilty. Now, I should explain, because New York does things in an odd way, the way they label their courts. In most states, the Supreme Court is the highest level court in the state. New York does it differently. New York calls its trial courts the Supreme Courts. So there's Supreme Courts all over New York State. They're just the bottom level trial courts. And New York calls its highest court the Court of Appeals. Most states would use the label Court of Appeals for their mid-level appellate courts, just below their Supreme Court. But New York State just uses different labels. So when they say Supreme Court here, they mean a trial court, not the highest court in New York State. Continuing with the news story, an NYPD source previously told the Daily News that 5 passengers called 911 before and during the encounter. One said Neely was making threats and harassing people. So these will be recorded. This will be good evidence for Penny because it's independent of him. It wasn't just him irrationally or speculatively perceiving a threat by Neely. 2, incorrectly reported that Neely had a knife or gun and was attacking people. Well, they may have been reporting that because perhaps Neely claimed to have a knife or gun. They didn't see one, but if he claims it, are you allowed to believe him for purposes of reporting to 911? Sure. Other callers reported the Marine was restraining Neely until the police got there, which of course would be fine. Prosecutors say Neely got on the train and started making threats and scaring passengers. That's what the prosecutors are saying? The prosecutors are saying that Neely got on the train and started making threats? When Penny approached him from behind and put him in a chokehold, Neely isn't accused of attacking anyone. Well, of course, you don't have to wait to be attacked, right? Self-defense, one of the elements is imminence. You're allowed to defend yourself against the attack that's about to happen. You don't have to wait for the attack to actually happen. You have to have a reasonable perception that the attack is imminent, either in progress or immediately about to happen. Neely isn't accused of attacking anyone. Well, you can't accuse him of anything. He's dead, right? And the witness who filmed the viral video, journalist Alberto Vasquez, said Neely told passengers he was hungry and didn't seem like he wanted to hurt people. Wait, but the prosecutor's saying he made threats. So which is it? Can you be hungry and make threats? Sure. I'm hungry. Give me your wallet or I'll stab you. Neely got on the train at Second Avenue and was on the filthy floor with Penny's arm around his neck. I wonder why the subway floor is filthy. You think it's because of riders like Daniel Penny, or you think it's because of riders like Jordan Neely? Just a thought, a question from someone who spent many an hour on the New York City subway system. With Penny's arm around his neck when it reached the next stop, footage of the latter stages of the incident shows Neely trying to escape Penny's grip with his legs flailing until he went limp. Medics pronounced Neely dead at the hospital after transporting him from the Broadway Lafayette subway station. Penny initially walked free, sparking protest over... Oh. All right, that is the timer, folks. The open access portion of today's Law of Self-Defense show is ending. If you're a Law of Self-Defense member watching this on your member dashboard, don't go anywhere. Don't go anywhere. We're staying right here with you. If you're watching this on YouTube or Twitter or Rumble, your stream's about to end. Now you can continue enjoying today's show by becoming a member of Law of Self-Defense for just 99 cents, folks. 99 cents for 2 weeks. Unlimited access to our members-only content. After that, stay a member. Virtually everybody does. It's only about 30 cents, less than $10 a month to be a Law of Self-Defense member. You can do that right now at lawofselfdefense.com/trial. You'll be emailed immediate directions for how to access the member dashboard and watch the continuation of today's stream there and be able to ask your questions and make comments in the chat, to which I will respond. And of course, you'll get the playback version of this show and all our members-only shows as well. All of that for 99 cents, folks. There's 300 of you here just on YouTube. Some of you have 99 cents. If you enjoy this content enough to be spending your time watching it right now live, I might suggest you might enjoy watching the rest of the show and our thousands of other pieces of members-only Law of Self-Defense content by becoming a member at lawofselfdefense.com/trial. So, to all of you on YouTube, I say adieu. Have a great weekend. Stay safe. And I hope to see you over on the Law of Self-Defense member dash.